Yeah.
Right? Thank you.
Arrest me or get the hell out of my
How was a
Right
complaint?
now, you can stand up. You can walk
No, I'm not. So you can arrest me.
You refuse to leave, you are going to be arrested
For what? I
How was a
have to break the law in public for you to arrest me.
You are no. You are
Patty,
under arrest
he's
for
twisting my
trespass.
wrist. He's twisting my
You
wrist.
are under arrest.
Okay, I'm going dead weight. Please don't twist my wrist. You're not stronger than me, bud. You're not stronger than me. Let go of me. Let go of me. You're not stronger than me.
I don't want to hurt you.
Hey there, welcome back to U.S. Corrupt Cops, your go-to channel for diving deep into the complexities of law enforcement interactions across the country. Today, we're unpacking a heated encounter at the Cheektowaga Police Department, where a citizen's attempt to file a complaint spirals into a clash over free speech, recording rights, and allegations of police misconduct that'll leave you questioning where the line is drawn. But before we jump into today's story, if you enjoy this video, drop a 1 in the comments. And if it's not your cup of tea, let me know with a 2. I'd be so grateful if you'd take a moment to share your thoughts in the comments below before you go. Now, let's get into the heart of today's case. On December 5th, 2024, William Reynolds, accompanied by his wife Patricia, visited the Cheektowaga Police Department in Cheektowaga, New York, to lodge a complaint. Patricia recorded the interaction, which included an extended discussion with Sergeant James Ratowski.
If you'd like to listen, but I don't think it's going to help because part of it's against Lieutenant Slavatiski.
Okay.
Yeah. So I got a question. Your body cam's on?
Yes, sir.
Okay. Just a question. Then maybe you could answer, and I just want your opinion on it. I'm a big guy, right?
Okay.
Are you guys allowed to, like, you guys have to follow the same laws I do. The uniform, that badge doesn't give you extra rights or privileges, right? So if you put your hands on a citizen, a private citizen, without rights, or without reason, and nothing is done, the lieutenant, I asked him in the office when he took me back to the other day, I said, if I was to right now get up and shove you in the shoulder like Officer Grant shoved me, what would happen? He told me, I would laugh at you. Right then I should have crossed that desk. Right then I should have crossed that desk. When we come out this door, I asked him again, what would happen if I put my hands on you? I would laugh at you. About 10 seconds later, now if you like to see the video, I've got it from you. He says, I'd laugh at you for being so stupid for getting arrested. That's entrapment. He also cursed at me. I can't get a lot of your officers to identify. I can't get the name of an officer I filed the complaint on because Hodgkiss says, well, we put the complaint in, but I'm not going to tell you which of the 3 officers there cursed at you.
Okay.
Even though she knows.
Okay.
I was put on 941 paperwork.
I'm sorry, I'm unaware of
No,
all
I'm
the
just like,
situations.
like I said, that's why I'm asking to speak to the captain of the chief.
Okay. I can.
I would love for you, all I need from you, because they have an office here, right? You can go speak to them. Let them know William Reynolds is here. He will be here until they come see me.
Okay.
If they don't come see me today, I'll be posting my videos online and you guys can deal with the complaints and calls that you will get.
Okay.
Because, like I said, your lieutenant cursed at me, tried doing trapping. Like I said, there's just a ton of stuff. So if you want to go either tell the chief or the captain, William Reynolds is going to be sitting in your lobby. He will talk to every person that comes in.
Okay.
He will video record everything. He will.
I can do a couple things for you. I can. I think they're in an administrative meeting right now. I can leave a message for you. If you'd like, I can. I can direct you to his phone.
You need an answer. I've already called him twice.
Okay.
They don't call me back.
Okay.
That's why I'm in person.
Okay, gotcha.
Because I'm allowed to sit in this lobby and record all I want. I'm allowed to talk to people that come in. I'm allowed to ask your staff things. I'm allowed to record your police. I'm going to ask why I've been pulled over for a plate blocker, for my plate being illegal, my plate holder being illegal.
Okay.
You guys have vehicles out in your private lot with toll blockers, front tinted windows, and he says, well, they're on a private lot, so I'm not going to ticket them. My next thing is I'm going to sit out in a lawn chair waiting for them to leave. I'm going to call 911 every time someone leaves.
Okay.
You guys are going to either hold yourselves accountable or I'm going to do it. You will either be the consequences for yourself or I will be your consequences. It's not going to happen anymore. Your officers are not going to run free doing whatever they want, cursing at people, being... here, let me see my... you can stop this for a minute. Stop.
William Reynolds asserts that under Section 240.20 of the New York Penal Law, a police officer cannot be considered a victim in a disorderly conduct charge. An individual may be found guilty of disorderly conduct if, with the intent to cause public inconvenience, annoyance, or alarm, or by recklessly creating such a risk in a public place, they use abusive or obscene language or make an obscene gesture. The Supreme Court in the 1987 case of City of Houston versus Hill clarified that the First Amendment safeguards significant verbal criticism and challenges directed at police officers. The Second Circuit Court of Appeals, which oversees New York, ruled in the 1999 case of Court Officer Shield No. 207 that only fighting words directed at police officers can be criminalized. The fighting words doctrine is likely narrower when applied to police officers, as a properly trained officer is expected to exhibit greater restraint than the average citizen. Thus, provocative speech aimed at officers is protected from censorship or punishment unless it is likely to produce a clear and present danger of a serious substantive evil that exceeds mere public inconvenience, annoyance, or unrest. Citing this and other cases, the U.S. District Court for the Eastern District of New York in the 2015 case of Stern versus Shamus held that under New York's disorderly conduct statute, abusive or obscene language is not unlawful if it is constitutionally protected. Language directed at police officers is only unlawful if it constitutes fighting words that are likely to incite an immediate breach of the peace. The Supreme Court in the 1942 case of Chaplinsky versus New Hampshire defined fighting words as those that, by their utterance, inflict injury or tend to provoke an immediate breach of the peace. For a police officer to be a victim of a disorderly conduct charge, the individual must act with intent to cause public inconvenience, annoyance, or alarm, or recklessly create such a risk. However, a citizen can be convicted of disorderly conduct for directing fighting words at an officer if the public harm element is satisfied. For example, in the 1997 case of People v. Tishner, the New York Court of Appeals upheld a disorderly conduct conviction against a citizen who shouted an obscenity at an officer, spat toward the officer's feet, and shoved him while yelling further obscenities as he passed a bar. Although the defendant claimed the interaction was a private exchange, the court found sufficient evidence that the defendant intended to cause a public disturbance, as bar patrons gathered to watch, necessitating the officer to call for backup. Thus, New York's disorderly conduct statute permits an officer to be a victim of such a charge if the defendant intends to cause public disorder. However, using profanity or name-calling against an officer without causing public harm does not constitute disorderly conduct.
Like I said, if you want to go tell either Coons or Jarris that it's going to be a long day for them.
Yeah,
it's going to be a long day.
I'll pass the message along. I don't know what's on.
That's all I want. And you don't have to say anything else besides it will be a very long day, or it's going to be a difficult time until they come see me. And,
okay.
And I'll be here until they do, and I'll keep calling, and I'll have other people call on my behalf. They can either stop this now and be men and come out here and talk to me, and be adults, and hold their officers accountable for the bad things they do, the lies they tell. I'd appreciate passing on. I appreciate talking to you.
No
like
problem.
I said, I get, in the long run, you have to protect your department and your job. I get that, and it's not about a personal thing against me. It's just you can't say something, whether you believe it or not. You're pretty much playing PR right now, and I get that. We'll let the captain and the chief, we'll let them say their stuff.
Yeah.
When I came in and filed my complaint, I was told by the male officer, I should have gotten his name. He told me that I said I want your officer arrested or charged with disorderly conduct. I'm not going to charge my officer with disorderly conduct. We should have arrested you for like 80 times. Arrest me. I am a First Amendment auditor. I'm sure you know. I'm sure you've heard of Long Island audit. I'm sure you probably know of Dan Warmus auditing here in county.
Yeah, I watch Dan's stuff.
Yeah, I do that stuff too. Though the one that cursed at me, he needs to get a disorderly conduct violation. Interference is physical, correct? And it's physical, right? Interference. If you charge me with interference, it has to be a physical. My words are not interference, right? Me just being there is not interference. Your officer having to take his attention away from his call is not interference.
When you say interference, you mean like a specific a criminal charge?
Yeah.
Okay.
Interfering with an officer's duty or whatever.
Yeah, okay, I apologize. Yeah.
No, that's fine.
Typically it is.
So me just talking and being there, that's interference?
If I can't speak for that situation.
No.
Yeah.
In general, is interference, it literally says in the statute it's a physical act. So why are we going round and round? It says in the statute, interference has to be physical.
Yeah.
You know.
So that's all I'm asking, yes or no? Interference has to be physical, right?
I mean, again, we can go hypotheticals all day.
It's not hypothetical. In the statute, does it say it has to be physical?
It doesn't say physical, no. So if you're, and interference, let me kind of push on that. That is not a quote-unquote charge that we have here. Are you referring to obstruction?
I'm sorry, yes, that's
Okay.
what it is.
Obstruction of governmental
It's physical.
administration, yeah. It could be physical interference, but again, hypotheticals. If I'm trying to investigate a situation, if I have somebody in the middle of the situation who's uninvolved.
You can put up tape. That's the beautiful part.
Screaming, yep.
Could
Put up tape?
You can put up, let's not use that.
Yeah.
Screaming is your addition. I don't scream at people.
Yeah.
William Reynolds contends that obstruction requires a physical act and that citizens have the right to record a traffic stop from any public location. Section 195.05 of the New York Penal Law states that a person is guilty of obstructing governmental administration when they intentionally obstruct, impair, or pervert the administration of law or other governmental function, or attempt to prevent a public servant from performing an official function through intimidation, physical force, interference, or an independently unlawful act. In the 1977 case of People v. Case, the New York Court of Appeals ruled that the term physical applies to both interference and force, stating that mere words alone do not constitute physical force or interference sufficient to support an obstruction charge, and that interference must be at least partially physical. Applying this precedent, the U.S. District Court for the Eastern District of New York in the 2017 case of Charles v. City of New York found no evidence of physical interference under the obstruction statute when an individual repeatedly ignored orders to step back and aggressively recorded close to an officer's face. Similarly, Section 79P of the New York Civil Rights Law grants individuals not under arrest or in custody the right to record law enforcement activity. This right does not permit actions that physically interfere with law enforcement or constitute a crime under the penal law related to obstruction. Thus, under New York law, courts are likely to find that individuals can generally record traffic stops from any distance, provided they do not physically interfere with an officer's duties, and they cannot be convicted of obstruction unless their conduct involves physical interference. However, state laws provide broader protections for recording than the First Amendment. The Charles case noted that courts have recognized the right to record police activity is subject to reasonable time, place, and manner restrictions, and this right may not apply if the recording interferes with police activity. Unlike the obstruction statute and the Right to Record Act, First Amendment interference is not limited to physical acts. The Charles Court found a factual issue regarding whether the plaintiff's filming interfered with police activity for First Amendment purposes, even though it did not physically interfere for obstruction purposes. Thus, a court may find that a citizen's filming does not constitute obstruction and is protected by New York's Right to Record Act, but may not be protected by the First Amendment if it interferes with police activity in a non-physical manner.
I appreciate you, officer.
Yeah,
If you want to go tell the chief and the captain.
William, right?
William.
And then, Pat?
Patricia, yeah.
Patricia, I'm sorry.
And let them know
Nice to meet
William
you.
Reynolds. They know who I am. I guarantee you.
Okay,
already.
I'll pass the message along.
This will not stop until my needs are met. This will not stop. I can be here every day. I can record. I will protest. Y'all can hold yourself accountable or I will do it. Like when I ask for an officer for charges to be filed against an officer,
Yeah.
and they tell me they won't do it, I'm asking you to file charges. You're an officer. It's what you do. You don't get to decide whether, I'm not going to do it. I asked you to file charges, right? It should have been done, correct?
I can't speak for that. If you, let me.
As an officer, right now, I am
Yeah.
asking you to file charges against the officer that swore at me for disorderly conduct, and I want charges for disorderly conduct against Officer Slavotiski for cursing at me in his office.
Yeah. Would I file charges against Lieutenant Swalaticki or that other person? I wouldn't. I would generate a report. I would generate a complaint of some sort. But me personally not being involved in the situation, I would need more proof.
That is your job. You
Yep.
are not the court. You are not the judge. You are not the attorney. You just cite the person. You let them deal with it.
So specifically for disorderly conduct, it being a violation in New York State, unless
Anything that
I
is
guess it
caused
would
to
be-
disturb or alarm. I was
Yeah.
alarmed that he would call me while he is on the job. I am alarmed. I am letting you know the circumstances. I would
Yeah.
like Slavitisky, and I'd like the body cam footage to be seen, and I'd like your other officers cited with disorderly conduct. Just say, we don't need to go back and forth anymore. Are you going to cite them, yes or no?
Me personally, I wouldn't review that situation, sir, because I don't think it happened on my shift, number
It doesn't
one.
matter. You're a police officer. A statute was broken. I would like Black Chief, who was on today. I know he's on because I saw your paperwork. I want him to come down. He was there. I'd like him to issue the citation.
The citation to...
For disorderly conduct against the officer that swore against me. He was there. He saw it happen, right?
Okay.
You saying you can't do it because you weren't there. I'm asking you for the sergeant that was there, that showed up on scene, and heard your officer curse at me.
I think with the complaint that you have, if they address that further today with you, I would address it with either Captain Gervais or the Chief of Police, whoever speaks to you.
Okay.
But as far as me filing charges or Sergeant Black Chief filing charges against an officer...
But I'm just going off of you gave me a bunch of reasons why you wouldn't or couldn't, and I'm giving you reasons why that guy can. And they're the exact reasons why you said you couldn't.
I'm not trying to speculate or argue with you.
Me neither. I just want to know that if someone wants to file a disorderly conduct charge with you, that you're telling me because you weren't there, you won't file it. I'm not asking you to be judge, jury, or a lawyer. I'm asking you to file a charge and let the judge and them decide. You have body cam. If it didn't happen, then he walks free, right?
It would definitely go up.
It's good to know that no matter what happens, they will not file charges against their officers. They will not hold each other accountable at the time things happen. So, I'm gonna let you go so you can get your calls.
Sure.
If you'd let the chief and or captain
absolutely.
know,
Again,
appreciate it.
nice to talk to you, nice to talk to you, dear.
Hey,
Yeah.
if I got high feet anyway, I get a
That's
little
okay.
emotional about this. So.
It's no problem at all. Happy to talk to you. If there's anything else we can do, let you know. Again, I'll pass the message along. I don't know what they're
Just like I said, just let them know I will be here all day, every day until they want to talk to me.
Thank you guys.
Appreciate it.
Have a good day.
William Reynolds requests that Sergeant Ratowski file a disorderly conduct charge against Lieutenant Slavitisky, who used profanity toward him, but Sergeant Ratowski declines. Under Section 140.10 of the New York Criminal Procedure Law, a police officer may only make a warrantless arrest or issue an appearance ticket for violations like disorderly conduct if they have reasonable cause to believe the offense occurred in their presence. Therefore, Sergeant Ratowski lacks the legal authority to arrest or cite Lieutenant Slavitisky, as the incident did not occur in his presence. Even if Sergeant Ratowski had witnessed the profanity, based on William Reynolds' account, it is unlikely he would have probable cause to arrest or issue a ticket for disorderly conduct. As previously discussed, Section 240.20 of the New York Penal Law states that a person is guilty of disorderly conduct when, with intent to cause public inconvenience, annoyance, or alarm, or by recklessly creating such a risk in a public place, they use abusive or obscene language or make an obscene gesture. The U.S. District Court for the Northern District of New York in the 2011 case of Potenza v. Gonzalez clarified that the disorderly conduct statute does not restrict pure speech directed at an individual, but targets words and actions intended to create a risk of public disorder. A court would likely find that Lieutenant Slavitisky did not intend to cause public disorder during what appeared to be a private dispute with William Reynolds. Additionally, the statute requires that disorderly conduct occur in a public place, defined by Section 240.000 of the New York Penal Law as a place accessible to the public or a substantial group of people. Since William Reynolds stated the incident occurred in Lieutenant Slavitisky's office at the police precinct, which is presumably not open to the public, a court would likely conclude the speech did not occur in a public place. Most importantly, Lieutenant Slavitisky's speech is likely protected by the First Amendment. The First Amendment protects profanity unless it constitutes fighting words, as explained in the 2000 case of People v. Livio by the District Court of Nassau County. Speech, even if abusive, vulgar, or provocative, remains constitutionally protected unless it presents a clear and present danger of serious harm or is calculated to provoke an immediate and violent breach of the peace. Thus, a court would likely find no probable cause to believe Lieutenant Slavitisky committed disorderly conduct.
To be clear, I want you to be clear with what's going on with me here. I'm not leaving. I'm not trespassing. I'm broken the law.
What I'm telling you is, if you disrupt the normal operations of our police station, you will be...
How so? How would I be disrupting? Let me know so I don't do it.
If our dispatchers can't sit here and conduct their work with you without you disrupting them,
Wait, hold
then
on.
officers will be arrested.
Sit there?
Okay? And you need
I
to have
didn't
a
disrupt them there. How did I disrupt them
You need to
there?
have a legitimate purpose for being here.
I am. I would like to see the captain or the chief.
They are not available. You will not see them.
I will sit here all day and I'll come back tomorrow and I'll come back every subsequent day until they see me. You're not understanding. I'm disabled. You have no authority over me. You're not going to tell me what to do. You don't intimidate me. You understand that?
I'm sorry that you feel that way.
So we can get the chief.
I want to be very clear.
Who are you?
I'm
Please
Captain
identify.
Schmidt.
Captain Schmidt, let's get some.
Perfect.
Perfect.
We are not going to continue in this pattern. You are interrupting the flow of our operations.
You would let me know how I'm interrupting. I would like to know how I'm interrupting.
All of your complaints are
You said I
closed.
knocked on the window and I'm
Listen, because I need you to hear this. All of your complaints are closed. If you're dissatisfied with how they've been dealt with, you can follow up with the Attorney General's office. That is your remedy. If you're further dissatisfied with how you've been treated, you may follow a lawsuit, get yourself an attorney and do that. What we are not going to do is we're not going to have you sit in our front lobby. We have a
You
duty.
can't do anything about
We have
it.
a
You can't do
duty.
anything about it, Captain Schmidt.
We have a
You
duty
can't do anything
to keep
about
this
it, Captain.
lobby open for the other members of our town to come in and file reports.
You're 100%
for
right.
victims of crime to come in, for people to come in.
Is
and
this a
get their
public lobby?
reports.
It is on the onus of you to create privacy. You don't want to
That's
talk to
right.
me, bro. I know
You're
more than you. I know
exactly
more
right.
than you. I know more than you.
I just want you to understand what I'm saying.
Are you going to arrest me if I
If
don't
you
leave? Are you going to arrest me if I don't leave?
Yes. Yes.
You might
I
want to
am.
put the cuffs on me right now. Put the cuffs on me
I
right now. I'm not
absolutely
leaving.
am.
I am protesting. I am in your lobby protesting.
So I want to be clear.
First Amendment
You have
right.
No legitimate
First Amendment
business.
right.
You're creating a disturbance.
Where?
I have a question.
There's other
Those
people.
are operations.
One person now. There's one person here. What disturbance?
He's the
He's
mailman.
He's the mailman.
Okay.
I'm their mailman too.
Yeah.
Right?
He's my
Thank
mailman.
you.
Arrest me or get the hell out of my
How was a
I am telling you
complaint?
Right now, you can stand up. You can walk out.
No, I'm not. So you can arrest me.
You refuse to leave, you are going to be arrested
For what?
How was a
I have to break the law in public for you to arrest
You are
me.
no longer welcome in this area.
Why? I'm First
Because
Amendment.
you're creating a
Is it a
disturbance.
First Amendment
Your
right
cause
to?
is to interrupt the flow of our operations.
How? How? What did I? Okay.
Our front desk lobby is now closed because of your attitudes, because of your actions, because of
They've
your
never
behavior.
been out
The
here.
Yeah, I
dispatch
asked
do not
what-
feel safe being at the front desk with you.
They're
That's not my
behind
problem. That's not my
glass.
problem. If you don't feel
It is.
safe, then you should be a cop.
Okay,
So
are you buying bullets?
So this is.
Let me
this
ask
is-
you a
this is what it
question.
comes
Let me
down
ask
to.
you a question.
You can leave or you can be arrested for trespass. You are no longer welcome in this
Stop
lobby.
How-
That's it.
Stop, mom.
How
I want
are
to know
you-
what live.
Stand up.
I want to know what live.
Stand up.
I am
Stand up
passively.
and turn
I'm
around.
passively aggressive. Passively.
Stand up and turn around. You are
Patty,
under arrest
he's
for
twisting my
trespass.
wrist. He's twisting my
You
wrist.
are under arrest. Stand
Okay,
up.
I'm going dead weight. Please don't twist my wrist. You're not stronger than me, bud. You're not stronger than me. Let go of me.
Listen.
Let go of me. You're not
Bubs,
stronger than me.
Bubs.
I don't want to hurt you. I don't want you to get hurt.
How can you
How
say?
are you?
How can you say a complaint was closed that was never filed?
That's what we have here.
Please stop twisting my wrist. I'm putting my hands behind my back. Patty, you see how rough they're being with me?
How can you say a complaint was closed that was never filed? We are here to file the complaint and you're saying it's already closed.
You are under arrest for trespass.
Well, go on, I break the trespass. It doesn't matter. I have to break the law. I have to break the law,
And you can
sir.
take that up in court.
Okay. Just
You
like
have to wait out here.
That's fine. I haven't gone anywhere.
Captain Schmidt orders William Reynolds to leave the police station, and when he refuses, William Reynolds is arrested for trespassing. Section 140.05 of the New York Penal Law states that a person is guilty of trespass when they knowingly enter or remain unlawfully in or on premises. Section 140.00 defines premises as including buildings in real property, stating that a person enters or remains unlawfully when they lack license or privilege to do so. A person who enters or remains in premises open to the public at the time does so with license and privilege unless they defy a lawful order to leave issued by the property owner or an authorized person. In the 1981 case of People v. Hedman, the First Department appellate term of the New York Supreme Court explained that even on public property, First Amendment rights may be regulated to prevent interference with the property's ordinary use by other members of the public. The critical question is whether the manner of expression is incompatible with the normal activity of a place at a specific time. In the 2008 case of People v. Reap, the Kings County Criminal Court upheld a trespassing conviction against a citizen who refused to leave a police precinct after being ordered to do so. However, that case differs from William Reynolds' situation. In the Reap case, the defendant demanded to speak with a non-existent detective, became irate, and began yelling, leading the court to find the order to leave lawful, as allowing the defendant to stay would interfere with the precinct's operations. In contrast, William Reynolds had a legitimate purpose at the police station, as he was there to file a complaint that had not yet been accepted, and he was not yelling or posing a safety concern. Thus, while William Reynolds defied an order to leave, he could argue the order was unlawful, meaning his refusal did not constitute trespassing.
Start again from the part where you're no longer accepting complaints from my husband.
So, and I would be very clear on this, so there is no confusion. Every time we have an
Wait,
interaction-
I need you to say we
I'm
are
getting
no.
there. I'm
Okay.
going to build to that
Okay.
point, so I'm going to say it very articulately,
Okay.
so there's no confusion. Every time we deal with your husband, that is a targeted attempt, in our estimation, for him to complain about our officers. Every time we have an interaction with him, what follows is another complaint. We have adjudicated complaint after complaint after complaint. We are not going to continue to entertain this behavior. We are not going to continue to use our manpower and our resources to focus on one person who is trying to interact with the police to make complaints. We're not going to.
You understand, though, if your police were conducting themselves professionally, if they were not calling my husband an, if they were not lying to both of us, we wouldn't be in this
So
situation.
there are other avenues for him, as I already explained earlier. He can go to the Attorney General's office if he believes we're not handling these complaints seriously, if we're not investigating them fully. He can file a lawsuit. Those are avenues to him that are legal avenues. Once we're at the point where I say you have no legal purpose in this building any longer and you are interfering with their operations and you need to leave,
Right.
at that point, he had to leave.
Because you came out saying the complaint was filed and closed.
Yeah, so,
But we hadn't
and
even
what we're
filed
not
it yet.
doing is we're not just going to continue to do, okay, that complaint's closed, I'm doing a new complaint. Well, I don't like the way they talk to me, it's a new complaint, it's a new
Well,
complaint. it's a
so
new
here's the issue,
It's a
though,
drain
when
on police resources.
I understand.
After William Reynolds' arrest, Captain Schmidt informs Patricia Reynolds that the department will no longer accept complaints from her husband. The status of the trespassing charge against William Reynolds remains unknown, as does whether he plans to pursue further action outside the Cheektowaga Police Department. Thank you so much for sticking with us until the very end. You're one of the few who go the distance. If you found this video insightful or thought-provoking, please hit that like button, and if you can, share it with your friends to spread the word. I'd love to hear your take on today's story, so drop your thoughts in the comments below. See you all tomorrow for more.